is Channel 7 News at 6.
Good evening. We begin tonight with reaction to a federal judge's decision this week to strike down parts of an Arkansas law regulating libraries. The law sought to impose criminal penalties on librarians and booksellers for distributing harmful material to children. Channel 7's Andrew Mobley digging deeper into the legal battle today. He joins us now with more. Andrew.
On Monday, federal judge Timothy Brooks of the Western District of Arkansas permanently blocked the state from enforcing the most controversial sections of Act 372, calling them unconstitutional.
We were excited and pleased, gratified by this outcome. It had been a long time since the legislature in March of 2023 enacted this law that we believed was unconstitutional from the beginning.
Act 372 put Arkansas among an increasing number of conservative states pushing for measures to restrict access to books containing material deemed obscene or harmful to minors. Books conservative lawmakers have honed in on, like Gender Queer, a graphic novel that depicts explicit sexual acts on several pages. According to Coulter, that book is not in the children's section of his library system, but the adult section.
We are not providing obscene materials in any part of the library. Some person's definition of what might be pornographic may be in the library. It has sexual content, but we're not providing that in the children's section of the library.
Coulter said the Central Arkansas library system already adheres to existing federal and state laws prohibiting the distribution of obscene materials. He says even if stricken sections of Act 372 were constitutional, they would thus be redundant. Obscenity is evaluated by federal and state courts using the Miller test. However well-intentioned, Judge Brooks said in his ruling Monday that Act 372 was overbroad in its ban of works deemed harmful to minors and would allow for arbitrary censorship outside the criteria of obscenity. He blocked enforcement of Sections 1 and 5 of the law. Section 1 would have allowed criminal charges against librarians for allowing minors access to materials deemed harmful by the state. The law did not specify how or to what extent librarians should prevent access to such materials. For example, a librarian may be liable if a child wandered outside the children's section and found such material. Section 5 would have created a process by which citizens could challenge library materials and request they be relocated, and would have given city and county officials final say over what materials could be included in a library's collection.
There are lots of books in our library that I don't want to read, and I wouldn't want my children, if they were young again, to read. But the library does not want, and I think most people in Arkansas do not want, the state legislature telling us that we're going to allow local elected officials to remove books from the library.
Coulter says he is confident that the ruling at the district court will be upheld if its decision is appealed. On your side, I'm Andrew Mobley.
All right, Andrew, thanks so much. And in response to the court's decision, Governor Sarah Sanders released the following statement. She says, Act 372 is just common sense. Schools and libraries should not put obscene material in front of our kids. I will work with Attorney General Griffin to appeal this ruling and uphold Arkansas law.